All right, folks, we're going to get started here. Sorry for the late start. This time of year, everybody's running around presenting bills. In fact, that's where the chair lady is. She's presenting a bill in another committee. She thought it may take a little bit, so that's why I'm sitting right here. So hopefully she'll be back sooner than later. Let's go ahead and get started by calling the roll.
Representatives Bricken, Farmer,
Here.
Gant, Garrett, Harris, Jernigan, Littleton, Powell, Stevens. Chairman Farmer, you have a quorum.
Okay, thanks. Perfect. Folks, we have just a few. I'm going to make just a couple announcements in regards to bills. We have two separate calendars labeled here. We have an adoption calendar. It's got 5 items on it. Item number 1 on that calendar, House Bill 164 by Representative Butler, is going to be rolled 1 week. 1 week's the final calendar, so that'll be rolled to the final calendar without objection. And moving down to the regular calendar, items 5, 6, and 7, which are all 3 Representative Shaw's bills. Item 5 is House Bill 1515. Item 6 is House Bill 862. Item 7 is House Bill 1032. Those are all going to be rolled 1 week as well without objection. Item 9, House Bill 467 by Representative Hemmer. That'll be rolled for 1 week without objection. Item 11, Item 14, House Bill 1395 by Representative Harris. That will be rolled to the final calendar without objection. And I think I've gotten, am I good there? Okay. And we're going to go and start with our regular calendar, out of order, if it's okay, members, with item 11, House Bill 1225 by Leader Lamberth. Motion. Second. You got a motion second, and you're properly recognized. Looks like that bill has an amendment, 5312.
Yes, sir, Mr. Chairman. It makes the bill.
Makes the bill. Members, should we get a motion and a second on that? Motion. Very good. You got a motion and a second on the amendment, 5312. Any questions or comments? You guys want to get that in the right form as we go? Looks like we do. All those in favor of adopting House Amendment 5312, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're recognized.
Thank you, Mr. Chairman. And Mr. Chairman, thank you for allowing me to steal this bill from you. You were gracious enough to loan it to me for this particular idea. So it originally had a really good sponsor, and I hope I can do it justice. This bill just gives judges the authority to grant somebody a restricted license if they fall behind on child support. Right now, they have to revoke their license, then it goes to the department, then they get on a payment plan, and then it finally comes back around to a restricted license. This just gives the judge the full discretion at the beginning to say, look, you're behind on child support. I'm going to grant you a restricted driver's license for whatever reason and whatever capacity that they feel it is necessary.
Very good. Members have any questions for Leader Lamberth before we vote? Motion on the bill. Any objection? Seeing none, looks like we're ready to vote to send House Bill 1225 as amended to civil full. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Very good.
Thank you, Mr. Chairman and members of the committee, and thanks for taking me at first. I think some of you are in criminal justice subbing a little bit, so I'll be over there. But thank you.
All right. Thank you, sir. All right, that brings us to, remember, if it's okay, we're going to move down to item 2 on the regular calendar by Representative Travis. That is House Bill 619.
Thank you, Mr. Chairman.
It looks like you have an amendment, 4574. Does that make the bill?
That makes the bill.
Members, we want to go ahead and get that amendment on there?
We need a motion a second.
Second. And then that's on the bill. We need a motion and a second on the amendment.
Motion. Second.
Very good. You got a motion and a second on the amendment.
Thanks, sir.
All those in favor of adopting House Amendment 4574, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended. You're recognized.
Thank you, Mr. Chairman. This will just allow the commissioner to notify the committing court at least 15 days prior to the proposed discharge of a child. Right now, under law, they're not required to do that.
There we go. Members, questions? Questions been called. Any objection? Seeing none, looks like we're ready to vote to send House Bill 619 to civil full. All in favor, say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Mr. Chairman. Committee.
Thanks, sir. Looks like we can move down. I saw Representative Leather. Aha, right in front of my face. Very good. Let's item 1. Item 3, House Bill 630 by Representative Leatherwood. Looks like there's a couple amendments there. I just need a motion and a second on the bill. Looks like there are a couple of amendments, 4292 and 5586.
I just had the one, 5586,
It's the newest one, it's the latest one, I'd say, so.
and I think that incorporates the earlier one as well. So I think we only need 5586.
Okay, all right,
If that's okay.
yeah. Does that make the bill?
Yes.
Rewriting, okay. Members want to get a motion and a second on that amendment? Second. Are we ready to, we want to vote to adopt the amendment on the bill as moving forward so we can explain it? Okay. All those in favor of adopting House Amendment 5586 to House Bill 630, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended, and you properly recognized before the committee.
All right. Thank you, Mr. Chairman and committee. This bill implements the two legislative recommendations from the Comptroller's audit of the Department of Children and Services. The first one deals with the caseloads of the case managers, and the second recommendation dealt with the reporting and investigating of non-consensual sex acts at some of the residential facilities of DCS. So again, this is implementing the two legislative recommendations from the Comptroller's office.
Very good. Thank you for that explanation. Members, do we have any questions for Representative Leatherwood? Representative Bricken, you're recognized.
Thank you, Mr. Chairman. I wish I had more time to kind of prepare for this a little bit, but I apologize. I have just, in my heart of hearts, have trouble with bracketing case numbers into law. I just don't think one size fits all, and putting future case reductions in place just doesn't seem like the appropriate way to legislate a department. I mean, I'm not an expert. I don't think anybody's an expert on DCS. But I mean, what I understand is that in certain parts of the state, you have case managers with underloads, and in certain populated areas, maybe overloads, and somehow putting these, well, somewhat arbitrary case statements in here just doesn't make management sense to me. So I don't know if I'm going to support this or not. I'll leave it at that.
And I know that, I believe Representative Leatherwood's been working with the Department of Children's Services, but you're recognized, sir. I apologize.
I'd say, you know, that's a good point. One size doesn't necessarily fit all for sure, but just through the research, looking at what's going on, we are able to come up with numbers that make sense. But to your point, the legislation does give the commissioner the opportunity after, you know, this is implemented, it gives the commissioner the opportunity to come back to the Governor and General Assembly, you know, if any of these caseload requirements are unfeasible or unwarranted. So it does take into account what you're saying, but you know, we all know there are problems finding employees these days and so forth. So I think given the 600-page audit report, this is something we just really need to do to try and get to this caseworker load. It is phased in, and there are reporting mechanisms along the way so that if, again, using the terminology, if it's determined that these are unfeasible or unwarranted, the commissioner, you know, this allows for the commissioner to report on that and take that into account. But I think this is just something we really need to do to bring these caseloads down. This also increases some of the supervision and just some of the flexibility. You know, it implements employees that just have the flexibility to move where the need is. Like you say, if one county there's not the need, it just gives it flexibility there. So I think it's important that we take this step, given where we are today.
Any follow-up, Representative Brickett? If so, you recognize.
Thank you, Mr. Chairman. I partially understand what your statement you just made. I just know all cases in DCS are not alike. All territories are not alike. I certainly know they need more employees, but that's not the issue. It just seems like we are, by doing this, we are, say, mandating operational details that I don't think we should do as legislators in this area. I just my gut feel says this is a mistake, and I'll leave it at that.
And thank you. And I have Representative Harris on the list to speak. You recognize, sir.
Thank you, Chairman. So on this, what is the current caseload right now?
I'm not sure what the average current caseload is at this point.
Okay, and
I'm
so
sure there are people here that could answer that.
I guess we're gonna go out of legal, ask legal.
Members, if you don't mind, we can go out of session. I believe Ms. Insoni probably answered that question. Without objection, we're out of session.
Elizabeth and Sonia, Legal Services. Under the current Section 37.5.132, the department is required to maintain staffing levels of case managers so that each region has enough case managers to allow caseloads not to exceed an average to be calculated at least monthly of 20 active cases relating to initial assessments, including investigations of an allegation of child abuse or neglect, or 20 children monitored and supervised in active cases relating to ongoing services.
Representative Harris, did that answer your question?
That answers the question. Well, I guess we need to go back to, I think that's all I have for legal.
Okay. Members have any other questions for legal, including
Can I ask
Representative?
legal something?
Go ahead.
Yeah, that's what is in the law. But I don't know if your question was, do you know if that's actually are they actually able to adhere to that at this point? Or is the reality on the ground something different? I thought you were asking the reality on the ground.
Kind of, because that's where I'm going to in this next statement that I'm gonna make.
Yeah.
Okay. And and you know what? Let's do this. Do we have, who's here with DCS? They're on the
Yeah.
list.
And I would think it'd be hard for you to answer the reality on the ground. But
Since-
again, I thought that's
Yeah,
was your
that's
question.
kind of where I'm
Good.
headed.
Since we are out of session, would you mind stepping up here maybe and answering that question for us if you can, ma'am? So to be expeditious with our time. You were down here to testify, so we're appropriately postured. If you would, just make sure red light's on, introduce yourself there to the committee. And
Sure. Sammy Mayfair, Deputy General Counsel, Department of Children's Services. I don't have a, as we sit here today, number of what our average caseloads is. It is a number that we have been struggling to meet as required in the statute because of the current situation that we found ourselves in.
okay, Representative Harris, any questions?
Yeah, so if the current is 20 in the law now, what is it that's going to allow us to maintain these numbers now? Because it looks like it's still 20 until January 2026. It'll stay 20 and then it'll go down to 18. So if we're unable to manage the 20 right now, what are we going to be doing differently to get to that number?
Go, you recognize.
Thank you. So the department has instituted a number of initiatives currently to get us to be able to hit our statutory requirement as it exists. The commissioner has a great vision, I think, for the department going forward. We have on our own instituted a requirement of a caseload cap of 10 cases for new case managers, and we are working on meeting that. So the various initiatives that Commissioner Quinn have instituted over the last few months since she's come in are getting us there. We believe that with those additional resources, with the additional work that we've been doing, that this is realistic for us to be able to meet. That's also part of why, when we've been working with the sponsor and working with other individuals, the idea of waiting until 2025 to institute the hard cap of 20 instead of the average, and then having that graduated approach plus a few other things contained in the bill to help provide administrative support. So this also authorizes a special response team, administrative work, other things for caseworkers who are not carrying cases. So in circumstances where there is an influx of cases or whatever the circumstance may be, we will have those resources to be able to go and absorb that and still keep that caseload cap for our existing workforce.
So I'm kind of where Representative Bricken is with it, putting a hard number in when we're not even meeting the number that we already have is a little difficult. But I guess my other question will be for the sponsor.
Okay. Members, do we have any additional questions for the department while we have someone here? Representative Bricken, you recognize?
If my problem is the caseload reduction, if there are administrative issues that this bill also takes care of that you talked about as far as emergency supervision or whatever like that, that certainly is a different manner. And if, I don't know if we can amend this bill to get my heartburn right and get just the administrative stuff done, but I don't see us passing legislation for future reductions when we haven't even gotten to the point where the current limits are satisfied. So I'll leave it at that, because right now I probably cannot support the bill.
Okay. And we're still in session, members. Any additional questions for the department? Okay. Thank you so much. Any
Thank you.
Any additional questions for legal before we go back in session? All right. Seeing none. Without objection, we're back in session. Back on the bill. Representative Leatherwood, we do have a calendar next week. Sounds like some members have some questions maybe they would like to walk through, maybe talk through with you. What would you like to do?
Well, I think Representative Harris had a question. If I could take whatever questions the committee
Sure.
has and then make the
Representative Harris, you recognize.
determination and respond.
Sure.
Well, I guess the last thing is just, as part of this, I know they mentioned administrative, but is the stair-stepping the dates put in place in order to allow the new staff to come in, actually get trained, while the older staff, the older staff caseworkers are able to carry the heavier loads, and the newer case workers are going to be carrying the smaller loads, or how's this working to make it to where it's going to eventually get down to 15 cases at a time?
Well, it is gradually rolled in to allow the department to hire the needed personnel and train them. Now, whether or not they give all the how they distribute those case loads, harder work to these people, lighter to those. You know, the bill doesn't get into that aspect of it, but just giving the time to get the people on board is why we bring it in gradually.
Okay, and if this is, if this one gets passed out, then it's funded, right?
Well, and that was the point I was going to make with, yes, the department might not be hitting the targets in law now, which, again, as I understand, is an average. This wouldn't be an average. You know, with an average, that's great if you're the guy with 10 cases, but the person with 30 cases to get that average of 20, that doesn't work out quite as well. So this goes from the average to actual. But where I think it's important that we move forward with this bill, be it this week or next, when we pass something into legislation, into law, the money comes with it as well. So there's a fiscal note on here. So this is not only a mechanism to set up the criteria we've talked about, and I appreciate the department. She explained the part with administration and the flexibility, but that's what I was talking about. This does create the flexibility of supervisors, different managers, intervention teams, that do not have a regular caseload so that they can move from those areas that are well covered to those areas that are not well covered. And I think this is important and critical flexibility to give the department. But again, as much as anything, moving forward with this and giving them the funding to start moving towards the objectives and goals that we lay out here is just very, very important. Again, I don't know how many people have had the opportunity to peruse the audit, but you know, this is frankly just a great step.
Well, the bottom line is
doing
the
that.
money's there. The issue is not money. There's unspent monies with the department, as I remember from last year and year before last testimony. The issue was finding people
Yes.
to employ. And I know the department had switched some monies around and tried to made some efforts to advertise for employment, maybe even increase wages there for those caseworkers. So I don't think it'd be an issue getting this funded, basically because I believe those monies are with the department now.
Yes, you're correct. And unspent money goes back to the general fund, as I understand it. But I think going from 20 average down to 15, it will be an increase of money over time if they can get all these positions filled. So.
All right. Members, any additional questions for Representative Garrett? You're recognized, sir.
Thank you, and I was in and out. But when you started, I was presenting a bill in another committee. What if we don't have enough employees to have a minimum number of 20 average cases to handle these? I mean, what if I guess my question, I'm reading your language in the, does the commissioner or the supervisor have any discretion to go above that number in case we have a labor issue that we're not going to be handcuffing the Department of Children's Services on the cases that they can manage if indeed they should go more than the 20 or in whatever year that we're in when they have a maximum amount of cases they can handle? Is there any discretion to allow them, oops, we can go to 25 and we're not subject to our scrutiny, subject to the Senate scrutiny, then subject to the governor's scrutiny under the way I understand this bill is drafted?
Yes, that flexibility is in there. The target, as Representative Harris alluded to, 20 in January 25, 18 and 26, 15 and 27, you know, those are targets, but the legislation does account for just the reality of hiring the people can be a problem. And what it puts in the bill, if average case manager caseloads exceed 20 for 2 consecutive months, or if 10% of case managers have caseloads exceeding 20, there's a reporting mechanism. So again, before things get too far out of hand, there's the reporting mechanism if the situation that you laid out happens, that the commissioner will then notify governor, lieutenant governor, and speaker of the House, as well as posting information on the website.
Okay.
Because again, this legislation and everybody that's worked on this realizes that hiring people and training people, getting good people on the job and to stay on the job is a difficult situation. So there's no criminal penalties or anything if these objectives are not met. But I think it's important for the General Assembly to address these issues and lay out our expectations while, which this bill does, putting in the flexibility for the reality out there now.
Okay.
So I think it does meet what you laid out.
Thank you, Chairman. Appreciate it.
Members, any additional questions? And I just want to bring up one point. I'm just thinking through this, thinking ahead. I think this is great policy. And policy versus reality, two different things. But the one thing I think would be helpful in passing this legislation, at least if these unspent monies go back to the general fund, we don't pass this and we end up hiring, the DCS has the opportunity to hire a lot of folks, are they going to have money there in place to hire? If we pass this, that money's at least, I think, would be there for them to use if those folks are available to hire. I don't know if they would be if we didn't pass this or not. So that's just a question I have. I don't know if you know the answer to that. I'm just kind of thinking ahead here on this.
Yeah, I don't know if legal or somebody would have more answers, but it's my impression, again, and I understand what they don't spend now goes back to general fund if they don't have the people.
Right.
So there is, I hate to say excess money, but there is money available in the budget for them to hire more people at this point. But to your point, I think passing this legislation, if we're reducing those numbers, it will require more money and will require us to step up more with that.
Okay.
So, yes, I think it will, if not today, eventually provide more money, more resources for them to rectify the problems we have.
Very good. Representative Bricken, you're recognized.
Thank you, Mr. Chairman. There, again, might be always operating in a confused state, but the governor's general budget, I thought already had a significant DCS increase in it for staffing and wage increases. This bill, at pass, would just require a supplement to the governor's already proposed budget. Am I anywhere close?
Representative Ledwood, do you know the answer to that question?
I cannot say for sure, but as we've been alluding to, I don't want to say cushion or whatever, but I do think they have money in their budget where they could hire more people now. They've been unable to hire the people they want to. Now, whether or not there's enough money in the budget to hire enough to get them on track with this legislation, someone else would have to answer that if they know. But shooting from the hip, I don't know that there would have to be anything in the governor's supplemental budget to do this. But again, I'm shooting from the hip with everything else we've discussed here. And
Yeah, I was just looking over the fiscal note. It talks about unspent monies going back to the general fund. So
yeah,
back to Representative Bricken, as you said, looks like maybe it would have to be in the governor's budget. These monies would have to be allocated there. I don't know if it'd be supplemental or something he's. I thought it was in his primary budget. Okay, maybe.
See, again, if you're looking at me, I'll reiterate, I would think there's probably enough in the budget to get us down this path without doing a supplemental. But again, I am more than happy, I'll say again, I'm shooting from the hip with that, just looking at rough information. But it was kind of eye-opening on the fiscal note to see how much they give back because they can't hire the people.
All right, members, I'm at the will of the committee, and so is Representative Leatherwood. Do we want to take a vote on this, or want a motion to roll it for a week? We do have another calendar. I think you're good on rolls. Sounds like there are some valid questions that folks need answered here. Would be, I think, helpful. Or if y'all want to take a vote, we can take a vote. I'll take either motion.
Thank you, Mr. Chairman. I would like to see this rolled 1 week because Section C I would like to see deleted and the other sections left in the bill. So,
Okay. Is that a motion to roll for a week? I got a second. Members, any objection to rolling House Bill 630 for 1 week? Say aye, or all those in favor say aye. Aye. Opposed, say no. Ayes have it. 1 week, sir.
Appreciate it.
Thank you so much. That brings us to, let's move to item 1, House Bill 563 by Chairman Todd. Patiently waiting back there. Thank you, sir. You got a motion and a second. I don't see an amendment on this bill, and you're properly recognized.
Thank you, Mr. Chairman and committee. This bill amends the solemnization of marriage statute to clarify that county mayors, county clerks, members of the county legislative body, and municipal mayors are prohibited from charging a fee or demanding any compensation for performing wedding ceremonies. We already have that in statute, but this creates a Class C misdemeanor criminal penalty for a knowing violation and a rebuttable presumption that the violation creates an actionable basis for civil removal proceedings. It only applies to local officials. We currently have the law, we just don't have any penalties on it. So it simply adds that, bringing this from the Comptroller's Office, who has discovered some current concerns with this.
Very good. Thank you for that explanation. Members, any questions for Chairman Todd? Representative Bricken, you're recognized.
Thank you, Mr. Chairman. Back in my life as a county commissioner, I've performed several ceremonies, all for free. But I was always offered to be paid or a gift or some thank you there. Is the bill says I just cannot charge, but if someone gives me a gift for doing a wedding, how does that make a difference?
Chairman Todd, you recognize.
Thank you, Mr. Chairman. It does not change anything about that currently that's in practice. So a gift, gratuity can certainly be accepted in any amount, is my understanding. You just can't charge up front and say, I require this much of a gift or gratuity. And they have had a situation that they discovered where that was being done. They literally gave a dollar amount of a required tip or gratuity, which is not really a gratuity, and you're exactly right.
Very good. Representative Bricken, good to go? Members, any other questions or comments for our sponsor? Question's been called. Seeing no objection, looks like we're ready to vote. Send House Bill 563 to Civil Justice Full Committee. All those in favor say aye. Aye. Opposed say no. Ayes have it.
Thank you, Committee.
Thanks, sir. I saw Representative Fritz there. Motion. Item 4, House Bill 731. You got a motion and a second. Looks like you have an amendment 5447. Does that make the bill or add to it or take away?
Thank you, Mr. Chairman. It does make the bill.
Makes the bill. Members, we want to go ahead and get that amendment on there. Looks like we do. Got a motion? Got a second. All those in favor of adopting House Amendment 5447 to House Bill 731, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're recognized, sir.
Thank you, Mr. Chairman. Committee, good afternoon. I do bring to you House Bill 731. This amendment narrows the scope of the original bill from any investigation conducted by Department of Children's Services found to be baseless to only those involving allegations of medical neglect. The amendment also establishes circumstances under which the destruction of such records can be carried out. These are very specific. The investigation was unsubstantiated. The allegations of medical neglect were the result of legitimate but conflicting medical opinions. And this bill was brought by our Senate sponsor for a specific case. I'll talk about that in a moment. The investigation has been closed for at least 1 year. The records are not relevant to any other investigation, and the district attorney of the jurisdiction consents to the destruction of the records. The amendment also makes this legislation applicable to the complaints referred to in the Department of Children's Services on or after July 1, 2026. This makes this legislation dependent upon the department having a technological ability to destroy the records. And as I understand it, that's the correlation with the date that I just gave you. Why is this legislation needed? Under Tennessee law, every adult who suspects that a child is being abused or neglected is required to report those suspicions to the Department of Children's Services or to local law enforcement. The person making the report can remain anonymous. I think we all agree that we want to maintain that. Failure to report suspected abuse is a Class A misdemeanor carrying a sentence of up to 3 months imprisonment, a fine, or both. Those who report and act in good faith are immune from any civil or criminal charges that may result. Clearly, as a state, again, we believe it is in the public interest to create an environment that encourages people to report suspicions of child abuse and child neglect. There is, however, an unintended consequence of encouraging people to report only what they suspect rather than what they can prove. Some of the investigations turn out to be baseless. This is especially true in cases involving cases of possible medical neglect because very often, medical opinions will differ as to what is the best course of treatment. We know cases, and this bill is brought to you for this reason, where parents had taken a child to an emergency room. The child was seen, treated, out of danger, and the parents advised of an ongoing treatment plan by that attending physician. The parents decide to get a second opinion. The ER doctor disagrees with the decision and reports a case of medical neglect. A subsequent DCS investigation shows there's no basis for medical neglect. Yet there is now a record that these parents were investigated by the Department of Children's Services. If we're going to encourage people to make these reports based upon suspicions, and we should, and the sponsor in the Senate agrees with that, we should not require the minimum level of burden of proof that is generally required by our justice system. We need to also encourage the clearing of the citizens' names and records when these reports turn out to be baseless. Currently, state law allows for DCS to destroy records of cases with no findings of neglect or abuse upon the youngest alleged victim's 19th birthday or after 7 years. This legislation would simply shorten the period of time in cases of medical neglect allegations to 1 year when the other requirements that I went through in the presentation are met. With that, I'll take any questions.
Yeah, thank you for that explanation. Members, any questions? Representative Harris, you recognize.
Thank you, sponsor. And so we had this bill, I think, very similarly last year. And one of the concerns that came up was the fact that for DCS, sometimes it takes a couple. The first report may have not came back as verifiable. The second one might not come back as verifiable. But then there's this third or fourth time that something happens, and they're able to utilize the information from the other reports in order to substantiate proof and evidence that this really truly did happen. Us deleting and getting rid of, removing and destroying all the records would not help for future cases that do come up for substantiality. So how would this help future cases rather than hurting them? How would this help future cases if something isn't able to be proven right now, but later on down the line it is? Can they come, if it's destroyed, how are they going to be able to utilize that information?
Representative Fritz, you recognize.
Thank you, Mr. Chairman. Thank you for that question. I would offer that some of the requirements that I laid out in the front help to provide those protections. Certainly, I know the sponsor in the Senate of this bill, and I personally hold those things to be very important. I happen to be resident of a county where a child was held in the basement and starved to death. And certainly, we have to be in tune to those trends that I think the representative's asking about there. I don't think that this legislation prohibits the use of those trends, and the buy-in by the district attorney and some of those other requirements to be able to destroy the records after 1 year are offered as those protections.
Representative Turner, you're recognized.
Actually, I have a quick question for legal, if we could go out.
Okay, we'll go out of session for legal. Since I knew you were recognized.
I'm looking at the fiscal note, and it says the passage that could jeopardize federal funding under Title 4E. I don't know what that is. I don't know if you do either, but is that DCS question? Okay. Well, we're out of session. Is DCS on the list? Okay. Yeah. Do I need to repeat the question, or?
Please turn on the microphone. You know the drill, and state your name and who you're with, please.
Sammy Mayfair, Department of Children's Services. No, Representative, I think I understand the question regarding the fiscal note with the $180,000 penalty. Is that correct?
Yeah. What is that? What is
Yes.
that? What is Title 4E? I don't know what that is.
Right. What that is referencing is because we are a Title 4E agency and we receive certain funds under Title 4E of the Social Security Act, we are also subject to federal oversight. And so we participate in a number of child and family services reviews that are conducted by the Children's Bureau. And they have the ability to institute financial penalties against the state if we are found to be out of compliance with those Child and Family Services reviews. One of the components of the Child and Family Services reviews is a comprehensive case history. And so there is the risk that if they determine that we are not maintaining a comprehensive case file on families that we serve, that we could be found out of compliance under that item of the Child and Family Service Review, which would be a financial penalty of up to $180,000 each time or each period under review. So that's why that's the base. We don't know what it would be, and we also don't know for sure whether or not they would determine we would be out of compliance.
So if we were to pass this, would we have to, do you have to, when we receive funds, do we have to have an amendment? Do we send stuff up to say this is our plan? Do we have to self-report this, or they just find out on their own that we're not in compliance?
They would find out when they're doing their Child and Family Service Review. So we are actually entering round 4 of our Child and Family Service Review currently. But one of the things that we would point to if that was raised as an issue is that we have a statute that would require us to do this. And so they may choose to take that into account or may not.
Okay. Thank you. That's all I have.
Representative Garrett, you're recognized.
Thank you. Thank you for coming up here. Is this a good idea?
Respectfully, I don't know that that's, I can answer that question.
It makes me nervous when, with children, when I'm reading this, with destroying records, that there's our patterns developed, right? So if we're eliminating patterns over periods of time, then those patterns are going to be forgotten. Then we're not going to have a pattern. We're not going to know. So I don't see in the bill, and I'm not asking you to opine on this particular section, but I don't see where there's any discretion. I do see where the district attorney general has to consent. My hope is that they have absolute discretion to consent where they can say, no, we're not going to destroy these records. But that's the spirit of my question. Is this, in your investigation with kiddos, is this a good idea?
So we have been working with the sponsor with the current bill and believe there are sufficient safeguards in place in this amendment to address those concerns. And that is, I think, the fact that, you have to have a year elapsed. It doesn't have to be involved with any other investigation. So, I mean, if we are getting other investigations, and even though this one was unsubstantiated, those records may be relevant to those other investigations. So they would not be subject to destruction under the way that the amendment is written. And I think, again, having that agreement of the individual that would be responsible for prosecuting an allegation of child abuse or child neglect within their jurisdiction, agreeing that it is appropriate for those records to be destroyed, that those are those rails in there to keep it narrow, address the concern that the sponsors had, but still keep children safe. It's also the responsibility of the individual to affirmatively ask for this. So it's not a blanket, these are just automatically purged from our system. The individual has to take that affirmative step of requesting and then meeting all of this criteria.
Just one follow-up. Thank you for that. I think you were clear, but just to make sure I clearly understand that for a request that's by the individual, and that's the only place that it can come from, the district attorney general has absolute discretion whether or not to consent to that record being destroyed, given the fact that they're the custodian of the record. Is that your understanding of the legislation?
The department is the custodian of the record, but yes, it is my understanding, the way that we've read it, is that district attorney would have the absolute discretion to say yes or no, and if they said no, it stops there.
Thank you very much. I appreciate that clarification.
Any other questions? Representative Jernigan, you're recognized.
How long do you keep records now? For how far back do you go? Or when they turn 18, they're sealed, and how does that work?
You're recognized.
So our electronic records, that is part of the reason that there is the note on this and the time frame. We really don't have a mechanism in place to purge electronic records. And so our TFAC system goes back many, many years. So we've had TFACs in place, I think, since 2006-ish. I don't want to speak wrong, but we've had TFACs in place for a period
Over
of
a
time.
decade.
And then another child welfare system that part of that data was imported into TFACs when we obtained it. So that all exists. Our hard files, we do have RDAs for, which I believe the sponsor mentioned when he was presenting the bill, of it's so many years after the youngest child has turned 19 that we destroy the records. And I think it's 7. I don't want to misspeak. I should know that. But it looks at the age of the youngest child in the family, and then so many years after that child reaches 19.
7?
I think it is 7. Please
Okay.
don't.
Okay,
me to
thank
that.
you.
Representative Harris.
So the next to last sentence in this, well, I guess, no. It says, so both the request and consent must be on forms developed by the department and made available to the public. So the private record that you all have, once somebody requests for it to be removed, then it goes on public record that it was that a notice was made.
No, I think that the intent of that is that we would have to develop forms, and those forms would be available to the public. So like post on our website the form that an individual would fill out to make the request to destroy the records. Not that the records themselves or notice of that would be made public, just the form itself that somebody would print off and fill out, that we would be responsible for creating that and making it available to the public.
Any other questions for DCS? Ms. Sammy? Seeing none, we're going to go back into session. Any more questions for Representative Fritz? Seeing none, are we ready to vote? All those in favor of House Bill 731 as amended, go into civil pool, say aye. Aye. Those opposed, no.
No.
The ayes have it. You move out to civil pool.
Thank you.
Without objection, I think we have some guests that have come back, traveled again for the adoption bills. So without objection, we're going to move over to them.
Madam Chair, so we're moving to the adoption calendar, and as I understand it, are we going to move to item 2, House Bill 551?
That's correct.
Okay, very good. That's by Chair Lady Littleton. Looks like there's 2 amendments listed on here, 4477 and 5660.
I want to go with 5660, please.
5660. Chair Lady would like to move 5660. Can I get a motion and a second? Motion? Second. Very good. We're going to vote and go ahead and, does that make the bill, ma'am?
It makes a lot of changes, so it'd be good to put it on if we could.
Very good. Remember, it sounds like we need to go ahead and put that on so she can explain this bill. Do we want to go ahead and do that? Looks like we do. All those in favor of adopting House Amendment 5660 to House Bill 551, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized, ma'am.
Thank you, Mr. Chairman. The amendment makes various changes, adjusting allowable expenses that can be paid for by potential adoptive parents, requiring courts to enter surrender order when all of the other conditions have been met, reducing surrender revocation periods when appropriate, adding rape offenses to the list of grounds for termination of parental rights, requiring DCS to file a petition for termination of parental rights within a set period of time when case involves heinous circumstances, strengthens and standards for punitive and biological father wishing to hold themselves out as the father of a child, prohibits adoptions from being overturned after a shorter period of time than currently in law, making it harder for parties to show up after everything has been done, prioritizing the search for kinship placements, and giving foster parents and other involved parties ability to be more involved in court proceedings, requiring DCS to accept outside home studies under certain circumstances.
Very good, and thank you for that explanation. I do have on our list, Mr. Mark Hodge has given your committee, your office notice to speak this week. Members, do we have any questions for your chair later? We can go out of session here from Mr. Hodge. Do you want to do that? Okay, very good. So without objection, we'll go out of session and hear from Mr. Mark Hodge. Sir, if you would, you can stand or you can sit, either one, if you want to make sure your red light's on. Introduce yourself, and we will have
Excuse me. Go ahead.
3 minutes to address the committee.
All right. I sat last week and I figured I'd just stand this week. Appreciate y'all. Newfound respect for y'all's schedules and the hours that y'all pulled watching y'all on video and then being here with y'all last week. Spoke to 164 last week. I know it got rolled. I did email to Ms. Kaufman a letter that says for Levi. That was what I referenced last week. This week, my wife was supposed to speak on this one. She could not travel, so I jumped in her spot. Wanted to just real quickly talk about some of these time frames that are really pertinent to us. A lot of what y'all talk about is so deep that it really goes over my head, but I'm at the end of that. Adoption, foster care reunification is job one. We understand that. Adoption is a totally different matter. Our life was changed in 2016. We were adopting a young boy, and he got sick, had an occlusion in his trach, was on 12 days on life support in Le Bonheur before he passed away. And so in that time frame, he was baby number 11 of a mother that was third generation foster care family. And so in that time, we had already signed all the papers. We even wanted to adopt him posthumously, after he passed away, but we could not do that. So, but in that point in time, the TPR kept on. DCS could not find her to get her to court for the TPR. But once he was on life support, she was there in a matter of hours. So a lot of these TPR time frames, okay, foster care, reunification, adoption, we want our babies. And so I just wanted to just show you a face to the tail end of what y'all are doing, why it's so important. We need DCS. They need all the help they can get, bar none. But on the end of this, adoption families, they would really like to see some of these time frames, decisions made and go for it. Just because you go to another rehab, I don't know how many times you go to rehab and get another 30, 60 days, and TPR keeps getting pushed off. So a lot of these time frames are really dear to us, and that's about it. Just wanted to be a face.
Very good. Members, do we have any questions for Mr. Hodge? Chair Lady Littleton.
Thank you, Mr. Chairman. I just want to thank you for coming back today and stating your case, and I'm very sorry what happened to you, but I do appreciate the fact that you were a foster parent, and we need more like you, so thank you for being here.
I think it's an honor. Very good. Members, anyone else before we excuse our guest? Thank you, sir. Thank you for being here. And that's all I have that given notice this week on the list to speak to 551. So without objection, we're going to go back in session. Chair Lady, you recognized?
I'm open for questions.
Members, she's all yours. All right, doesn't look like we have any questions or comments, so it looks like we're ready to vote whether or not to send House Bill 551 to Civil Justice full committee. All those in favor say aye. Aye. Opposed, say no. Ayes have it. That brings us to item 3, also Chair Lady Littleton's bill, House Bill 312. If I can get a motion and second. And you're properly recognized, ma'am.
Oh, sorry.
Okay. Okay. Sorry.
Thank you, Mr. Chairman. I think this is the first bill I've had in a long time with no amendment. So this is
She's got a motion and a second. She's properly recognized.
This is just a bill for adoption, the process to modernize it. The bill helps modernize DCS adoption process in 3 different ways. First, the bill corrects a recent court appeals decision misinterpreting when a court may find the grounds of persistent conditions exist in order to terminate the parental rights. The court found that the petition for the determination of parental rights to have been filed for 6 months rather than the child has to be removed from the home for 6 months. So it's changing it for waiting 6 months at the time of the TPR to when the child is removed. And it's second, the bill corrects modernizations practices related to the release and maintenance adoption records. And finally, the statute requires courts conducting adoption proceedings to send adoption records to DCS at various stages of the adoption process.
Very good, and thank you for that explanation. Members, do we have any questions or comments for the Chair Lady? Doesn't look like we do. And I did have DCS down, had given notice today. I don't think that was only if we had questions. Is that correct? Okay, all right. Are we ready to vote? Any objection? Seeing none. Looks like we're ready to vote. Send House Bill 312 to Civil Justice Full Committee. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. Now that brings us down to item 4 on the adoption calendar, House Bill 552, and then that also is amendment-free, Ms. Chair Lady. So members have a motion and a second? Motion. Perfect. You're probably recognized.
Thank you, Mr. Chairman. This bill puts into code that the goal of the Department of Children's Services must be to act in the best interest of the child at all times, and the goal must be reflected in any mission statement or motto established by the department.
Very good. And we also have, we have 3 individuals given notice to the office to testify today, members, just so you know. So we'll need to go out of session at some point in time. Do you want to ask the chair lady questions now, or we want to hear testimony first to go out of session? Very good. All right, objection, we're going to go out of session. All right, I have the Farleys. I have Aiden Farley, Chad Farley, and Jessica Farley. You 3 may come up here at the same time if you'd like, or one.
Yesterday, and we were told that we were going to be restricted just to one, since we're all the same group. I couldn't get clarification. Can we all 3 speak?
Okay, very good. And here's what we're going to do in order to be fair and transparent. We're going to give each of you 2 minutes apiece to speak, even though you're speaking on the same issue. So I think that's more than fair. So y'all can come here one at a time, or y'all 3 can come up here and sit down, whatever you want to do.
I believe my wife, since we were told that didn't prepare, so could my son and I have an extra 30 seconds apiece?
Yeah, and the chair lady saying yes.
All right.
So
Aiden, would you come on up here? Real quick, Ms. Chairman, woman, last week I do want to apologize to you openly about what happened outside. My son has prepared that speech for a long time, and to have it rolled over and see the hurt again in his eyes, it hurt me. So I apologize for that.
It hurt me as well, but we have a procedure that we have to take, and we thought we'd have more time than what we did, and I apologize that he didn't get to speak, but he's here today, so thank you.
Yes, ma'am. I'm trying to teach him how this all works. I got it, Aiden, it's right here, but
Okay, so you all will have 2.5 minutes apiece.
I'll go ahead and go first
So-
while you're looking. Okay.
If you would, sir, just go and just introduce yourself for the record. Once you do that, the timer will start.
One more time, I read lips.
Just go ahead and introduce yourself for the record, and then the time will start.
Yes, sir. My name is Chad Farley, and I agree with great people like Mr. Hodges. We need DCS. We do. And I hope this statement is an apology somewhat fit in there, that we understand that there's issues, and I hope Ms. Quinn really gets a hold of this. It wasn't in my child's best interest for DCS to unsubstantiate 13 allegations in person, but then drive to a lockdown mental health facility where my wife had been involuntarily committed for her first time, interrupt her critical mental health treatment to interview an acute psychosis patient, then mislead her during that interview about her son, pushing her further into crisis. It wasn't in my child's best interest for DCS to use that interview and collaborate with SWAT teams to storm my home and hold my son at AR gunpoint, where less than 24 hours earlier, DCS was welcomed in, calmly and civilly spoken to, and even given private access to my son for over an hour, unsubstantiated. It wasn't in my child's best interest to move him from my home, where 2 other adults he interacted with daily were. It wasn't in my child's best interest to place him with his maternal grandmother, who he barely even knew. It wasn't in my child's best interest to endure 20 more days after the caseworker herself reported witnessing the verbal abuse my son was reporting to everyone he talked to. 20 more days of this 10-year-old being called pathetic for crying about his father, who he missed, by a woman who was supposed to be comforting him with love. It was not in my child's best interest to be able to mourn the passing of his only grandfather just days after his removal, a man he loved dearly. And lastly, this is not how it's supposed to be. It's not. I upheld my promise to this country on May 3rd, 2002. I gave everything I had. I lost everything. I'm still waiting for my country to uphold theirs. It's time for someone on this committee to get my family's six, my back. I urge someone on this committee to take steps to open an independent investigation and really see how the laws and policies that you're passing are being misused also. Bonuses, all this, there's a lot in today's world that motivates.
And sir, that's your,
I
that's your
just-
2.5 minutes.
There's good families, and we need DCS, and I hope we can really work together. I'm not here to fight. I want to work with you guys. But I held up my end, and my family was destroyed out of hate.
Okay, thank you, sir. Thank you.
Thank
We'll
you
have
for listening.
unlimited
Thank
time
you.
for questions, so just hang right there. Actually, sit down beside your son if you'd like, or you can stand up if you'd like as well. And as soon as you introduce yourself to the committee, your time will start. Okay.
Hello, my name is Aiden Farley, and I was taken from my home 2 years ago at the age of 10. On April 11th of 2021, my mother suffered her first ever mental health crisis and left our home in the middle of the night. She will be found in a vacant parking lot 2 hours away. My mom was involuntarily committed and taken down to a mental health hospital for treatment. The next day, police showed up to my house with DCS after talking to me alone for an hour. I was taken back into my house where my dad asked if I was being taken. DCS said no. The next day, I was watching TV with my father when I looked outside and saw a trail of police cars flying down our driveway. Officers in vests and helmets with large guns pointed at us. Screaming officers everywhere, my father in handcuffs. If you ask what this 10-year-old saw on April 14th, 2021, just one day after DCS was at my house talking with me, that's it. The only thing that changed after DCS had talked to me was that the DCS woman left my house and went to the mental health hospital where my mother was being held to get help for a diagnosis that plainly stated she had no reality, yet DCS interviewed her. This was not in my best interest. When the SWAT team came in on April 14th, there were 2 other adults at my home who I knew that were safe, but DCS told me that I was going to my grandmother Michelle, who I had rarely ever seen. I've heard my mother talk about how hard her childhood was growing up with her mother, and we just did not spend time with her. This was not in my best interest. While at Michelle's, I was constantly yelled at and blamed for things that I did not do, which is hard because my mother and father have taught me right from wrong my whole life. I do not lie, and I believe my school teachers will tell you the same. I can remember the first time I was ever being dishonest because my father made me write an essay on integrity. What I remember above all was Michelle calling me pathetic because I was emotional and worried about my father, who is a disabled veteran who was injured serving our country, and was now at home alone without his caretaker. This was not in my best interest. DCS, my GL, and the CASA worker. I told them all how bad I was being treated every time I saw them. It wasn't until Miss Tabitha, my DCS worker, saw Michelle treat me like this herself that she believed me. Miss Tabitha was at Michelle's picking me up to go see my father and brother for the first time. I decided to write a note to get help and gave it to my brother under the table at the visit. By the time I got back to Michelle's, word of the note had already traveled, and even though I was being told I was going to get in trouble in front of DCS, as soon as Miss Tabitha pulled away, it started. This was not in my best interest. It will be a very long 20 days from the day my note was found for DCS to move me. 20 days of being scared, yelled at, and hearing awful and untruthful things about my parents. When DCS finally did move me, I was taken 3 hours away to a therapeutic foster home in Rickman, Tennessee. This home already had a child. I was used to having a brother and sister around, but not like this kid. This kid was truly out of control and very violent. I had my hair pulled constantly. I was punched, hit, and kicked. But the worst part was this 12-year-old was always biting. I would try and tell the foster parents, but they would always just tell him to stop. The scariest part is that they were replacing me with a young baby. This was not in my best interest.
Hey, Aiden, your 2.5 minutes up. Actually, we'll let you go a little past 3 there.
He's only got 3 sentences
It's 3
left.
sentences. Go ahead. Let's finish. I was trying to pay attention there. I couldn't tell where he's at. Go ahead and finish up, buddy.
Okay. I would like to leave you with something that I learned from my essay that my dad made me write. Integrity. Doing what's right even when no one is looking. It's clear through my story and many others around our state that the best interest has always been included in this law. It has only been in the best interest of DCS.
Okay. Good job. Thank you.
Thank you for
Thank
your
you
time.
so much for that. And, hey, gentlemen, if you'll just hang tight for 1 second, some of the members of the committee may have some questions for you. I don't know. Members, Representative Harris, you're recognized.
All right, thank you so much for speaking to us today. I did want to ask, like, you kept mentioning the grandmother. Why did it take 20 days for DCS to pull him from the grandmother?
Mr. Farley, you're recognized.
Mr. Harris, TFACs are littered with unsubstantiated claims all about different things, but nothing about why it took 20 days. Nothing about why 20 days. I believe the policy is 14 days. Is that correct, ma'am?
Sir, if you'll just, just
sorry.
address
I
the
believe the
question
policy
been
is
asked.
14 days, but we can't find why.
There you go. Representative Harrison, any additional questions? Very good. Members, anyone else for the Farleys? Representative Bricken, you're recognized, sir.
Thank you, Mr. Chairman. I guess my question is, do you think your issues of how you were handled is an individual personnel issue of DCS or a systemic issue throughout DCS?
Mr. Farley, you're recognized.
Representative Bricken, I can't thank you enough for that. Unfortunately, I think we all have social media. We all see the news. This is systemic. This is all over the place. This is everywhere. I don't think it's every DCS caseworker we have. No, I think we have some
Let me
great
interrupt you,
ones.
if I could,
Sure,
Mr.
yeah.
Chairman.
Remember, I
Bricken, you're
relapsed.
recognized.
I'm sorry.
I didn't. I mean, if you have a basis for systemic statements, that's fine. But because obviously you got an individual situation, but I mean, why would you say it's systemic versus just maybe a poor caseworker was assigned to you or overworked caseworker?
Mr. Farley, you're recognized.
Yes, sir. And absolutely, I think every one of our DCS social workers is overduced or overworked. How? Because this issue pushed me into finding out. I don't listen to how laws and all that are made. I was stupid to that. But I started diving in. I started looking at reports and looking at numbers and then going into different other parent groups and finding out. This is all over the place, and they're using everything you're passing up here, whatever, to fit the narrative. That's why, sir.
Any follow-up, Representative Bricken? Members, anyone else? Before we excuse our guests. All right. Hey,
Thank you for your time
we
today.
thank you both for being here. Aiden, you did a wonderful job. All right, without objection, we're going to go back into session. Now we're back on House Bill 552. Chair Lady Littleton, you're recognized.
I'm open for any questions, but it just makes the child come first in the mottos in anything that DCS does.
Question's been called. Any objection? Seeing none, looks like they're ready to vote to send House Bill 552 to Civil Justice Full Committee. All in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on. All right, folks, and Representative Chisholm's been patiently waiting, so we're going to move back to the regular calendar. Item 8, House Bill 820. You've got a motion, and you've got a second, and so you're properly recognized, and I don't see any amendments either, so you're free to address the committee.
Thank you, Chair and Committee. House Bill 820 immediately permits the overpayment of child support to be applied towards the individual's future payments until that overpayment is exhausted. With that, I stand by for questions.
Thank you, Mr. Chisholm. Are there any questions? Or Representative Chisholm, any questions? Seeing none, are we ready to vote? All those in favor of sending House Bill 820 to Civil Pool, say aye. Aye. Those opposed, no. The ayes have it. You move out to Civil Pool. This
Thank
is
you,
your
Chair and
lucky day. So we're going to go out of session for a presentation. If you guys would come forward and state who you're with, your name and who you're with, please. We're out of session.
It's on the desk.
and you just push the down button and it'll turn the screen on. He's coming.
There's just a lot to do.
Yeah.
Thank y'all very much for being here. Like Mr. He said, Mr. Hodges, right? What he said, now we know everybody knows what our schedule's like. It's just very chaotic this time of year, but we really thank you for being here, and we look forward to your speedy presentation. So go ahead, you're good to go.
I'm Lynn Farah. I have the great honor of serving as the president of the Joint Task Force on Children's Justice and Child Sexual Abuse, and we're happy to present to you today the accomplishments and the goals of the Joint Task Force. The Joint Task Force on Children's Justice and Child Sexual Abuse was enacted in 1985 by the Tennessee General Assembly to work with the Department of Children's Services and the Joint Task Force to develop a biennial state plan addressing Tennessee's response to child sexual abuse and other forms of sexual abuse. The plan was delivered to the General Assembly in January, and you should all have a copy of that. DCS collaborates with the Joint Task Force, a group of 48 child welfare, juvenile justice, health care, and mental health professionals statewide who are appointed by the Department of Children's Services Commissioner Quinn. We also satisfy a federal mandate through the Children's Justice Act and the Children's Bureau to identify goals to make child welfare improve in the state of Tennessee and satisfy the mandates of the different child welfare leaders that should participate on the Joint Task Force. Our collaboration between DCS and the Joint Task Force is vitally important to us. As I said, all of our members are appointed by Commissioner Quinn. We have Carla Aaron and Amy Koslick here, who are liaisons with DCS, and we meet with them regularly to get updates from DCS, but also to seek ways from them on how we can be helpful to the Department of Children's Services. So our collaboration is strong and ongoing. I'd like to introduce Tony Lawal, who is the coordinator for the Joint Task Force.
Good afternoon. And between 2021 and 2022, 10,648 adults received child sexual abuse training in Tennessee. 55,502 people completed the Child Abuse Mandated Reporter online training that's on DCS website. 2,353 law enforcement completed human trafficking training. 4,045 civilians completed human trafficking training. DCS also launched the Spanish version of the online mandated reporter training in 2021. DCS and the Joint Task Force also surveyed 619 school child abuse coordinators training needs related to child sexual abuse and Aaron's Law.
I would like to call on members of each of the committees that serve on the Joint Task Force. I'd like to introduce first Dawn Harper, who serves as the chairman of the Child Protective Investigative Team Committee.
Thank you so much. I am Dawn Harper. I'm the CEO at Nashville Children's Alliance, which is...
I don't think your mic is on.
I'm sorry.
There you go.
Better. Okay. I am Dawn Harper. I am the CEO at the Nashville Children's Alliance, which is the child advocacy center located here in Nashville inside the Family Safety Center. I serve as the chair of the SIPIT committee, and SIPIT, of course, as you know, is Child Protective Investigative Team. And I'm excited to be in this role, to serve on as the chair for this great task force. The SIPIT committee's goal is to improve the SIPIT coordination and response to child sexual abuse and severe child abuse cases throughout the state. I'm proud to announce that the SIPIT committee has revised the SIPIT Best Protocol practice manual for distribution statewide. We believe this resource will serve as a guideline for all SIPITs throughout the state. The manual is designed to assist SIPITs in addressing the child protective needs of their community. The ideas and procedures in the manual are meant to assist each MDT in doing the best job they can to protect the children they serve. And I would just like to thank you all for the great work you do here in supporting children and families of Tennessee. The children of Tennessee depend on our support and guidance, and we owe it to them to continue to protect them. Thank you.
Thank you, Dawn. I'd like to introduce Stephanie Etheridge, who is here on behalf of the Court Improvement Committee.
Good afternoon, committee members. My name is Stephanie Etheridge, and I am the Juvenile Court Manager and the statewide Judicial Safe Baby Court Coordinator at the Administrative Office of the Courts. And I do have the great privilege of serving on the Joint Task Force and also our Court Improvement Committee. Some of the things that I would love to be able to share with you this afternoon, very pleased that the work that our committee is doing, is steps to achieve our overall goal, which is to improve the effectiveness of child welfare-related proceedings across the state. And so one of the ways that we are doing this is we have ongoing collaboration and just really strong communication with our Juvenile Judges Executive Committee. And that is done through the Administrative Office of the Courts and with the great committee members that we have on board. We share suggestions for conference topics for them and also for their court staff. Additionally, we have been working hard to develop a pro se dependency neglect petition that pro se litigants will be able to access across the state so that they, when they come into the clerk's office, for example, they will be able to easily file a petition for custody. Another project that we've been working on for some time that we are very, very pleased about and to share with you today is we have developed a children's book. So children will be able to have a better understanding about what it means to go to juvenile court. And we have partnered with Davidson County Juvenile Court with their gang program, and we have the youth there that are actually providing the illustrations for the children's book. So it's been a great kind of community project for them as well. So thank you.
Thank you. I would like to introduce again Tony Lawal, who will be speaking on behalf of the Outreach and Awareness Committee.
Okay. So the Outreach and Awareness Committee educate and inform the public, child care providers, schools, child welfare professional groups, law enforcement, healthcare organizations, and other groups about child welfare related resources and training opportunities. This committee representatives include representatives from the Department of Children's Services, Human Services, Child Care Division, Department of Education, Department of Health, and other child advocates, including those with lived experience in foster care. Some of our accomplishments were related to the Aaron's Law. We updated that document that addresses child sexual abuse prevention and intervention curricula for public schools. It was actually disseminated widely to all the state child serving agencies and their contracted services providers. We included information in there for the population for age 0 to 4. It was most recently disseminated at Children Advocacy Days last week. There were like over 900 attendees there, and everyone got a copy of a Child Abuse Prevention Month flyer that talked about some of the topics. This is the flyer, what it looked like, about mandated reporter and child abuse overview training, information about Aaron's Law, sexual abuse awareness and prevention.
Thank you. And I would like to introduce Melissa McGee, who is here on behalf of the Treatment Committee.
Good afternoon. Thank you for allowing us to be here. My name is Melissa McGee, and I work with the Tennessee Commission on Children and Youth, and I am privileged to be a part of the Joint Task Force as well, and I serve on the Treatment Committee. Our main goals are to really determine the need for additional resources as it relates to children with sexual behavior problems, including some work around children who have experienced commercial sexual exploitation, And so our work over the past couple of years has been to address the children with sexual behavior problems. The treatment committee is really committed to understanding, reviewing, and disseminating information and materials on how to improve our work with children who may be exhibiting sexual behavior problems. We also have recently completed a document that addresses the commercial sexual exploitation of children. That is a 54-page document that really looked at what is known about children and youth who are commercially sexually exploited and provided just kind of an overview. We've also been privileged for several of our members to present on that document and other important factors at various conferences.
Thank you. So we wanted to honor our time and your time, and so we really appreciate the opportunity in the midst of this very, very busy legislative session to present to you about the Joint Task Force, and we would love to answer any questions that you have. Thank you so much for all that you do for children and families.
And thank you guys for being here, and sorry about the short time. When we booked this like a month ago, we didn't dream we'd be going as fast as we are and as busy as we are, but thank you very much. I'm interested in the book. You knew I would be, didn't you? So I'd like to see one of those, and I'd like to put one in my office because we try to put things in our office that kind of tells what we do in children and families. So if you could drop a couple by, I'd like that. So
It's not published quite yet, but it will be online, and I can let you know when it's available.
yeah, I want the first edition. No. So are there any questions for the task force? Anyone? Well, I guess you guys did a great job. So again, we thank you for what you do and appreciate you being here.
Thank you so much.
So we're going to go back into session. I guess all the bills that were left over will be rolled to next week. And if there's no other business, without objection, we are adjourned.